In the early 1990s, Congress and the Supreme Court engaged in a very interesting series of battles over the First Amendment's free exercise clause, and I actually published a series of articles analyzing these battles using principal agent theory. This was an interesting set of battles because it was not only a battle over how to interpret the free exercise clause of the First Amendment, but also a battle over who can interpret it. So it gets the fundamental questions of power in our political system. And it all started in 1990. For several decades before 1990, the Supreme Court had analyzed free exercise cases in a way that was very, very friendly to individuals who were claiming religious freedom. So groups that were typically unusual religions and their various practices were typically protected by the Supreme Court. And in legal terms, they used something known as the compelling interest test. Well, you don't need to know the details, but the compelling interest test is a test that makes it very difficult for the government to win these cases, and it makes it easier for the religious adherent to win. So until 1990, the Supreme Court was fairly friendly toward religious claimants by using the compelling interest test. However, in 1990, they surprised everybody by deciding the famous case of Employment Division v. Smith, where the court actually tossed out the compelling interest test. They reversed more than 30 years worth of precedent, and they substituted it with another test, the rational basis test, which is much easier for the government to win, which means it's much harder for religious adherents to win, meaning that religious adherents should lose more cases than they did previously. Well, this decision was extremely unpopular, really unpopular. Liberals hated it because they support religious freedom. Conservatives hated it because a lot of them are conservative and they support religious freedom. In fact, this united the Congress, and in 1993 they passed a law known as the Religious Freedom Restoration Act, and this law was passed unanimously in the House of Representatives and unanimously in the United States Senate. It's very unusual, of course, for major pieces of legislation to pass unanimously in both houses of Congress. This suggests how angry Congress was, and in fact most of the country was very unhappy with this decision because it was seen as negating essentially the free exercise clause of the First Amendment. And so the Religious Freedom Restoration Act was signed into law by President Bill Clinton in 1993, and what it did was it ordered the courts to go back to the old test that the court used to use before 1990. It's an actually extraordinary law. It mentions the court's Employment Division v. Smith decision by name. It says that it's wrong, and it orders the court to go back to the way that it used to be. Now, you may recall that the Congress, of course, has the right to pass laws overturning statutory decisions by the Supreme Court. The only problem here is that this was not a statutory decision of the court. This was a constitutional decision by the court. And the only way you can overturn a constitutional decision by the Supreme Court is through a constitutional amendment. And as a result, in 1997, the Supreme Court had to declare the Religious Freedom Restoration Act itself unconstitutional because the Congress doesn't have the power to tell the courts how to interpret the Constitution. So this is essentially the setup, and this is what you need to understand, that in 1990 the Supreme Court said we're going to become less friendly toward religion. In 1993, Congress said, no, you need to be more friendly toward religion. And in 1997, the court said, nope, we're going to declare that law unconstitutional and we're going to go back to the way that it was. So what I looked at in my study was how did lower courts, the interpreting population, and in this case it's also the implementing population, and in many cases, how did they respond to these conflicting demands? Did they respond to the court? Did they respond to Congress? Now, the interesting thing here is that the Religious Freedom Restoration Act was clearly unconstitutional. There were dozens of law review articles that had been written about this law, and every single one of them came to the conclusion that this law was unconstitutional, and of course it was. It's a fundamental principle of the law, as we've already mentioned, that Congress cannot overturn a constitutional decision of the Supreme Court merely by passing a statute. So it was clearly unconstitutional. And so the question I wondered is, would the U.S. Court of Appeals follow the Religious Freedom Restoration Act? Or would they follow the Supreme Court? This is a really interesting situation in which you have the Supreme Court and Congress both telling the lower courts to do a particular thing, opposite things, and the question is, will they follow the court, which they clearly should, but will they also follow Congress, which they clearly should not? Now, I argued that they would, that the lower courts would pay attention to Congress even though the law was probably unconstitutional, because almost everybody in America hated the Smith decision. As I said, it passed both houses of Congress unanimously. And so I assumed that just as most Americans hated the Smith decision, most lower court judges probably hated the Smith decision as well. And as a result, even though they were bound to implement the Smith decision, which they hated, as soon as Congress gave them a reason to evade the Smith decision, they would do so, even though RFRA was almost certainly unconstitutional. Well, what did I find? Were my findings borne out? They absolutely were. You can see from this chart that no matter what the time period, religious claimants do not win a majority of their cases. There was no year in which, or no period in which they won more than 35% of their cases. But what you can see here is before the Smith decision, when the Supreme Court was friendly toward religion, religious adherents won about 33% of their cases. But when the court reversed its stance and became more hostile toward religion, the lower courts followed suit, and as you can see, the support for those religious adherents declined to 20%. But then, after Congress passed the Religious Freedom Restoration Act, ordering the courts to go back to the old standard, the lower courts absolutely complied. They did exactly that, and you can see, in fact, the support for religious claimants went right back up to the same level that it had been before the Smith decision. And then, finally, in 1997, the Supreme Court declared RFRA unconstitutional, saying we're going back to the old, less friendly standard. Did the lower courts follow suit? They absolutely did. Support for these claimants went down to 20% once again. So the lower courts faithfully followed both the Supreme Court. They complied with the Supreme Court, but they also complied with Congress when Congress told them to not comply with the Supreme Court, even though that law was almost clearly unconstitutional. But again, I took this as evidence that the lower court judges wanted in their hearts to evade the Smith decision, and when Congress gave them any excuse to do so, that was an excuse they were willing to take.